Yes.
I'll just orally point out what it contained two aspects. My lords are aware, my lord, Article 371A, which provided that first take the list of three entries which the instrument of accession maintained, that is defense, communication, etc. And the president was to find out which are the corresponding entries in the union list. Because defense can have 5 corresponding entries, communication can have wireless, telephone, etc. 5. So, my lord, first act, my lord, which I have mentioned is that, my lord, with which your lordships may directly not be concerned, just by way of, my lord, an example that the Honorable President, by this first CO, identified the entries. That these entries would fall within those 3 broad subjects which the ruler has given under the instrument of accession. Then it is exercise of powers under 371D and applying these provisions of the Constitution of India. Your lordships would find I'm not reading union, relations between union and states, but all were applied with modifications. As Article 370 or itself, Lord, points out, for example, amendment of the Constitution. 368 was applied, but with a provision in sub-article 6 that any amendment made in the Indian Constitution would not ipso facto apply to the Jammu and Kashmir.
You follow the Article 370 route.
Unless applied through Article 370. So, my lord, in that fashion, Lord, the second part of this CO 10 is,
the first part was with consultation, the second part was with concurrence.
With my lord, concurrence. Concurrence, my lord, consultation is only qua.
As far as 368 is concerned, the Constitution can be amended in terms of that article by the Parliament and so forth. Now, as far as proviso to 368, it says that the Legislative Assembly can then adopt, or with concurrence, then it will apply over. Whereas D requires concurrence. Concurrence probably will be prior concurrence.
My lord, that would be so.
Because when we are talking about Constitution as it exists, 371D refers to the Constitution as it was originally enacted.
Okay.
368 refers to the amendments to thereafter. So there is a slight difference between the two.
Yes. So whatever amendment is made in any part of the Constitution would not apply unless it is so applied either fully or with modification and exception under 371D route.
It will be 371D route or 368 route.
No, it would be 371D route. So I'll tell you, lordships, why. Lord, suppose the Indian Parliament amends.
38 is not in this red book, no?
No, my lord, it is now deleted. My lord,
no, but the red book has a lot of other things, but some of the others not here.
Lord, would your lordships like to see, my lord, the original the CO? My lord, that your lordships would find. My lord, let us take a hypothetical illustration, my lord. Just, my lord,
It's just a matter of logics, that's all.
Yes, but only 2 minutes, my lord. The concerned amendment, my lord, in this CO is at page 4 to 9 in volume 3.
Volume 3, right?
CCD. Please come to, my lord, page 8, my lord. The directly, my lord, page 8. And I'll give one illustration only, my lord, at the foot, my lord.
371.
Yes, my lord, just to illustrate, my lord, for example, Constitution of India amended and inserted Article 21A, right to education, free education, etc. It never applied to Jammu and Kashmir till 2019 because this route was never followed.
Likewise, as you said, the preamble amendment of 1976
was applied with modifications, etc.
So the secularism and socialism amendment was never adopted in the case of Jammu.
Yes, even integrity word is not there. That was also not applied.
We can skip this now. We can go ahead.
Yes.
These things should not happen in our country.
When
I'm sure the AG will look at it.
Mr. Attorney General, just see what Mr. Sibal is saying.
I have checked up, Lord.
Yes.
After having read in the newspapers,
yes,
I did check up. And of course, Lord, the Advocate General is also here. But what is reported in the newspaper may not be the whole truth. He files petition.
It's not from the newspaper, Manoj. The order itself, 25th of August, I've got the order with me.
No, no, just a minute. And there are other issues also. We can place it before your lordships. And
But
in
then
any
it should
case,
have been suspended earlier. Why might?
He gave written submissions.
Written submissions here. But this is not fair. This is not the way that our democracy should function.
Mr. Attorney General, just see what has happened. Somebody who appears in this court is
it's not
suspended.
the ground, but we'll look into it. We'll
Have a look into it and just talk to the
Without doubt. Without any doubt.
talk to the Lieutenant Governor and see what has happened.
Fine.
Please don't read the note, Malad. I'll orally point out what it says. Lord, when I take your lordships to the position of Jammu Kashmir Assembly vis-a-vis our constitution, the Constitution of India and the Constituent Assembly of India, Lord, I read that proclamation just to show that it was intended to be subservient to and subordinate to the Constitution of India. But right now, this is a date that the Constitution.
Mr. Solicitor, you may deal with this, what I'm suggesting, but I'll forget it. So, I was reading your list of dates in the morning, the thought struck me.
Yes.
At one level, you may be right, or subject, of course, to what we have to consider on their rejoinder, that your argument is that the Constitution for the Republic of India is really a document which lies on a higher platform than, say, the Constitution of the state of Jammu and Kashmir. That J&K Constitution, according to you, is subordinate to the Union Constitution. That's one aspect. The second aspect, which you have tried to make out in your note, which we may elaborate it upon it later, which is your contention that, look, the Constituent Assembly of J&K was in the nature of a legislative assembly and not a constituent assembly. That, strictly speaking, that there may be a problem for two reasons. That's not how Article 372, bracket 2 refers to it. It refers to it as a constituent assembly of the state.
Correct.
But more important, once Article 238 made certain provisions of the Constitution inapplicable to the Part 3 states, and particularly the state of Jammu and Kashmir, including executive, legislature, judiciary, which would be brought into force by the Constituent Assembly framing a constitution for the state of Jammu and Kashmir, then it may be very difficult to call it a purely just a legislative assembly. That is an aspect which you may want to deal with. You may deal with it in just one sentence, and then maybe
segment, my lord, of my subject.
Then we will deal with it at that time on the list of days.
I am obliged. Your lordships would, my lord, note, when Constituent Assembly of Jammu and Kashmir was formed, obviously there was no legislative assembly, because that was yet to be a part of the constitution to be framed. So as to ensure that they do not lose their representation in election of the president, Lord, this CO was issued that you will be treated as legislative assembly also. Lord, your lordships would find at the end of this chronology, 370 has been applied in kind of a floating way. Whenever, my lord, it is required to use the word interchangeably, it is logically so used, and whenever any word has become otiose, it is replaced by its successor. Look,
at that point, there was no legislative assembly at all.
At all, correct.
Therefore, they had to make this CO
correct.
To read that instead of the word legislative assembly shall also include a reference to constituent assembly. Because at that point, there was no legislative assembly.
My lord, exactly that is where, my lord, I would respectfully drive it. When there is no legislative assembly, constituent assembly, the president has said that now it would be treated as legislative assembly. But that I'll come little later. Lord, it has been used, my lord, kindly see there are two, Lord, prominent features in COs which comes up.
Yes.
A, it has been used in a floating way, some words used interchangeably. And second, and most important for my purpose, whenever a word in Article 370 becomes otiose, for that post not being in existence, that body not being in existence, it is immediately replaced by its successor. Sadr-e Riyasat is replaced by governor, etc. There was a letter, my lord, referred to by Mr. Gopal Shankar Narayan, where Dr. Rajendra Prasad, the then Honorable President of India, writes to the Prime Minister, Honorable Prime Minister Nehruji, that this can be used only once, etc. That is being used, that can be used, my lord, in buttressing the arguments which I am also advancing, But we also got, my lord, the response of the Honorable Prime Minister. I'll put it, my lord, when that fact comes, my lord. And thereafter, the same Honorable President issued, my lord, order under 370 sub Article 3 also. So, my lord, literally, actions speaks louder than words. That was, my lord, the understanding, but the understanding was that it is so drastic a provision that use it only once. It's an self-extinguishing provision. That's my lord, the tenor of that order. Later. Lord, while the Constituent Assembly of Jammu and Kashmir was in session, Lok Sabha also continued its session. In New Delhi, as per Constitution of India, during one of the Lok Sabha debates, Lord, please see, my lord, how our parliament understood Article 370. My lord, the purpose is to satisfy your lordships that Article 370 is not just stated to be temporary. Legislative Assembly debate says it is temporary. Even during the subsequent parliamentary procedure also, everyone treated it as a temporary measure. But only for that, but this is N.C. Chatterjee. But incidentally, he was the counsel in Premnath Call judgment. N.C. Chatterjee, he must be a member of parliament also. That irrespective of 370, the President of India's right, which he exercises on behalf of the Republic, which he exercises on behalf of we the people of India, must remain as a plenary power without any fetters. My lord, that's how the parliament understood. But I may, my lord, just paraphrase it and proceed further. Lord, it says, every member says that this is temporary. They also understood it to be temporary. My lord, I am not laboring on the point right now why it is temporary. The point is, which I'll ultimately make, despite full knowledge that Article 370 is a part of the Constitution, despite having accepted in the Constituent Assembly debates of Jammu and Kashmir that it is temporary, they chose not to make any recommendation under sub-Article 3. My lord, that's a separate limb, and I'm just flagging it here. My lord, kindly allow me, my lord, to point out, my lord, this might appear to be striking because it is striking. It should never have been at the first given and should never have been continued. The effect of 370 with 367 or any provision of the Constitution is that by an administrative act of the Honorable President and the government of the state, any part of the Constitution can be amended, can be altered, can even be destroyed and not applied, and new provisions can even be created in Constitution of India. 35A, I'll come to it. Article 35A was created, which is a part of Constitution of India, only to be applied to the state of Jammu and Kashmir. That's why, my lord, this 371 route and 367 mechanism has been used more than once because 370 permits it. It stopped, my lord, only after 5th of August 2019. Otherwise, any provision, any article, my lord, it was placed much at a higher pedestal, as my Lord Justice Call rightly pointed out, than even a basic structure.